the entire prosecution team working this trial submit to training on Brady and other professional obligations of a prosecutor. This is actually embarrassing. This is quite literally a slap on the wrist. Judge Whitaker filed an order on defendant Stillwell's renewed motion for a fair and constitutional trial. The judge officially ruled on Stillwell's motion for a fair trial, and she gave a controversial ruling on whether or not Brady was involved in the ex parte meeting. These are all very important orders right here. I'm on literally 2 hours of sleep, so I'm going to try my best. Bear with me. Here we go. Hit subscribe. All right, first one. Shannon Stillwell's order on defendant Stillwell's renewed motion for fair and constitutional trial. Stillwell raises numerous assertions of error, impropriety, prosecutorial misconduct, and judicial partiality, which he asserts have resulted in a denial of his constitutional rights to due process and a fair trial, determining whether such events, if they occurred as alleged, warrant a mistrial with prejudice, dismissal of the indictment with prejudice, which would have the same effect, or disqualification of the prosecutors. Claim 1, a plague of discovery violations, missing police reports, and Brady violations. Discovery is being addressed. This court has ordered the state to timely produce all discovery and undertake a concerted effort to secure and provide all police reports, including asking current APD personnel with specificity to search for and produce reports on the case. Well, remember, all of them are lost in the hack. Or not all of them, but some of them were. And this isn't the first time the prosecution has been warned about discovery, but whatever. The court confirmed the state's understanding that Brady obligations include the disclosure of material impeachment items, and reminded the state of its continuing obligations under Brady, which they've violated several times. The state represented to the court that it fulfilled all Brady obligations. No, they haven't. Claim number 2, prosecutorial failure to follow court orders, making specious allegations against defense counsel and counsel for a witness, and lack of candor to the court. Any past failure of the prosecutor to follow orders of the court is a matter of record. Aside from the broad assertion of a denial of defendant's rights to due process and fair trial, no specifics establishing this assertion, no claim of resulting legal errors alleged. Any potential error stemming from the prosecutorial failure to follow court orders may be addressed on motion for a new trial or direct appeal, assuming any conviction. So once again, she's just saying appellate courts will deal with everything. What a shame. Any specious allegations against defense counsel, counsel for a witness, or lack of candor with the court is at minimum extremely unfortunate. These items do not, however, establish a denial of defendant's rights to due process or a fair trial, and the court at present declines to impose the extreme sanction of removal of any of the offending prosecutors. He basically just said it's unfortunate. I can already tell the public is not going to like Miss Whitaker after some of these orders. A defendant is entitled to a fair trial, but not a perfect one, for there are no perfect trials. Peoples versus state. Alright, whatever. Evidentiary error, which involves mistakes under Georgia's procedural rules and evidence law rather than any constitutional violation, can be addressed in post-trial review. So she's just pointing a lot of stuff to appellate courts. The court reminds all counsel that every Georgia attorney is bound by our rules of professional conduct and owes a duty of candor to the court. These ethical and professional obligations should be scrupulously honored, and prosecutors above all should endeavor to comport themselves so as to be above reproach on such matters. The court understands that as the authority to sanction counsel for violations of the rules of professional conduct that occur during an impact on a case before this court, the court declines that invitation at present. So she's basically doing nothing. She's just warning them so far. There's no remedies, nothing happening to the state. Claim for mistreatment of defendants and their counsel by the predecessor judge. Aside from a blanket assertion, the motion does not detail any alleged mistreatment of defendants. Alright, I mean, there's been several times where the judge yelled at the defendants' lawyers in front of the jury, called Brian Steele unprepared and unprofessional, and that's just 2, and I know there's at least like 5. The alleged mistreatment of defense counsel detailed is not alleged to have occurred in front of the jury, and even accepted at face value would not rise to the level of violation of defense due process or fair trial rights. Some of it did occur in front of the jury, so I guess whatever she's citing, it didn't. As to remedies, the predecessor judge has been recused, and the contempt issue is outlined as moot. This is her stating once again, well, he's recused, so none of that matters anyway. He's gone. Turning to alleged mistreatment in front of the jury, a judge has broad latitude in determining how to control the courtroom and directing attorneys to sit down when overruling objections falls within that latitude. Oh, so this is only about being told to sit down. This court will give a remedial instruction directing the jury to disregard any disparaging remarks about counsel. Claim 5, the ex parte bullshit. Claim 5, the June 7th ex parte conference. So this is one where they figured out that the defense actually knew it happened, but they didn't know about the substance, where the judge was going to call them outside agitators. Basically accused the defense lawyers of witness tampering, which is insane. The defense counsel was therefore on notice of this request. The defense also knew that this request was not to secure immunity for Copen, as the immunity order had been signed in open court earlier in the same day's proceedings. Even assuming a right to be present for this conference, no one of the defense team objected to the request or sought more information about it, thereby waiving any right to be present for that conference, citing Nesby versus State for the proposition that defendant waived right to be present by failing to object after being informed of trial judge's meeting with the jury outside. As for the topic of this ex parte conference, where the judge and prosecutors basically accused the defense counsel of witness tampering, so don't undermine it. but she's about to undermine it right here. Defendant assigns nefarious intent to Prosecutor Love and Hylton's representations about the interactions with Copeland's main counsel, Jonathan Melnick. The court at this point declines the invitation to so view their representations, but refers the prosecutors to this footnote. Defendant complains that comments by the predecessor judge during the conference reveals his partiality to the state. Pretermitting the questionable accurateness of such characterizations, this issue has been mooted by the recusal of that judge from the case. Alright, whatever, dude. So all the bullshit that Glanville did is deleted now just because he's recused. It's kind of crazy. He can coerce a witness to testify and talk shit about lawyers. It's fine because he's gone now. Now here's the big June 10th meeting. Defendant's motion raises several challenges to this ex parte meeting. Did defendant have a right to be present? Did the ex parte meeting amount to coercion of Copeland's testimony? And did any Brady violations occur? So this is a big one. I think there's some Brady in there, but I know she's going to say there isn't. Melnick came in the court on August 5th and talked about his point of view. Predecessor judge remarks regarding outside agitators are virtually identical to all the remarks he had just made on the same topic in open court, remarks which he addressed to all counsel, which could not therefore logically include defense counsel. So Glanville said something about outside agitators in open court, apparently addressing everyone. I don't remember that, but I guess I just missed it. Defense counsel also raises the specter of another ex parte conversation between the prosecution and judge. Portion was not transcribed because the predecessor judge seemed to know there being no prior mission of such list during the ex parte meeting. This knowledge is easily accounted for. The prosecutors has specifically referenced such a list of questions on the record during the prior Friday's proceedings, thus the innocuous source of the predecessor judge's knowledge. So apparently the list of questions that started all this, where the defense was like, wait, what? How does the judge know about that? Was addressed in open court. So apparently things were addressed in open court and defense counsel just missed it. Did defendant have a right to be present? Defendant is correct that this meeting was about more than just the parameters of Copeland's immunity and whether he understood its potential ramifications. The initial stage of the meeting, before the first break, centered on the prosecution's concern with whether Copeland's main counsel was laboring under a conflict of interest and with the logistics of handling Copeland's testimony with standing counsel. But because those topics were all ancillary to Copeland's immunity agreement, the topic of the meeting remained at its core and, as asserted by the prosecution, Copeland's immunity grant. Because the meeting dealt with Copeland's immunity grant and its ancillary issues, it was not a critical stage of the trial at which the defendant has a right to be present. Citing Snyder v. Commonwealth of Mass, she cites United States v. Gagnon. We've seen this one where they say basically that the defendants would just be a shadow in there and they're pointless to be in the room. The presence of a defendant is a condition of due process to the extent that a fair and just hearing would be thwarted by his absence, and to that extent only. Okay, it was clearly about explaining to Woody his immunity deal, but the main issue to me was them not disclosing it to the defense. And of course, telling Woody he's going to be in jail for years on end and coercing him. Defendant's correct that there are differences between the meeting in this case and the meeting in King v. State. For instance, the meeting in King was to secure immunity for a key prosecution witness, and defense counsel in King v. State was aware that the immunity hearing was occurring. In this case, they weren't. Here, the defense counsel was not given notice of the meeting, and immunity had already been granted to a key prosecution witness, so the topic was not whether immunity was in the public interest. Instead, its topics were the adequacy of the witness legal representation and logistics about standing representation, as well as ensuring the witness correctly comprehended the meaning and impact of the immunity grant, what would and would not amount to contempt of the order granting immunity and compelling his testimony, and the potential consequences of failure to comply with the order. A defendant has no right to be present for discussions with a tribunal surrounding witness immunity. The fact that here, discussions including what testimony would subject the witness to a charge of perjury, what would subject him to punishment for contempt of the order compelling his testimony, and what that sanction might entail, even if incorrect, does not change the analysis. Defendant's rights were still not the subject matter under consideration. See State v. Lowry. No right to be present at a hearing to compel witness testimony pursuant to immunity grant. Alright, so at least she's citing a few cases where the defense doesn't have a right to be there, but defendant asserts that certain arguably inaccurate representations made by the prosecutors and the predecessor judge to Copeland about the law of derivative use immunity, the applicable statute of limitations, and the length of his possible incarceration for contempt coerced Copeland in testifying. Webb v. Texas is the touchstone for evaluating claims of coercion by the trial court of a witness testimony. Archer v. State, they've cited this case before, provides another example of a trial court overstepping its proper role of neutral arbiter and rendering involuntary a witness' determination whether to testify. Here, Copeland had the benefit of counsel. I love how she's not saying recused judge, she's saying predecessor. Isn't that funny? All the defense lawyers say recused judge, she doesn't. The predecessor judge did not, on the whole, use intimidating rhetoric, but rather sought to ensure that Copeland understood the nuances of decision he had to make, and explained that many of decisions decisions about what could happen to Copeland were not his to make up or up to the prosecutors. Still, some of the information provided to Copeland may not have been accurate. While it is likely that Copeland was not induced by any inadvertent or any inaccuracy to testify, the cleaner approach is simply to pre-dermit this issue, acknowledging past inaccuracies, and advise Copeland anew. So she wants to completely tell Woody everything accurately. Was there a Brady violation? Okay, this is where it gets kind of interesting. This has been a long-running and multifaceted proceeding. Frustrations may have been mounting while fortitude was waning, and a needle in a haystack is not only sometimes difficult to find, but also easily overlooked. The court does not attribute bad faith to anyone on this issue. Alright, so clearly she's going to say there's no Brady violation. And yet, as soon as Copeland joins the June 10th in-chambers ex parte proceedings, he states, "I've never been truthful a day in my life until I just made the statement right now." Copeland may have little credibility, he may speak in hyperbole, but the fact remains that for a defense attorney, this nugget by a key state's witness is gold. So the prosecution not only did not reduce the statement to writing and produce it, but also asserted in court filings the defense had no entitlement to know the contents of the ex parte proceedings. This amounted to suppression, whether willful or otherwise, of what was objectively Brady impeachment material. Wait, so she's saying it is Brady. So it's a mistrial. Let's go, boys. The defense now knows of his statement and indeed all of what occurred during the June 10th meeting. Contents of the meeting were ultimately revealed during the course of the trial. Suppression of this information does not technically amount to a Brady violation. Alright. But the fact that a violation of a defense constitutional rights have been averted does not, under these circumstances, provide cause for celebration. What it does provide is cause for sober reflection and examination of processes, procedures, and approaches that permitted this likely inadvertent but nonetheless serious Brady lapse to occur. Defendant seeks as a sanction the disqualification of the state's two lead prosecutors, because this does not appear to the court to have been a purposeful violation, but rather a negligent overlooking of the impeachment value of Copeland's in-chamber statement. The court does not order their disqualification. Oh my god. She's saying it wasn't on purpose, it was just them being negligent. At the same time, the court is cognizant that defense liberty, as well as the liberty of his co-defendants at trial, is at stake, that the prosecutors involved are knowledgeable and experienced, and that this is not the first allegation of prosecutorial misconduct in this case. The court therefore orders a remedial measure that the entire prosecution team working this trial submit to training on Brady and other professional obligations of a prosecutor. This is actually embarrassing. This is quite literally a slap on the wrist. Wow. This training will consist of a video replay of training on this topic previously presented by the Prosecuting Attorneys Council of Georgia. So what do you know? The judge says there was no Brady violations. Everything Glanville did wrong is fine. And she puts a chief district attorney in Brady training. This seems fake. This doesn't seem like reality. I'm baffled. How is this continuing? I think they coerced Woody to testify. She says they didn't, but they just gave him bad information. And we'll just restart on his testimony. The jury didn't already hear days of his testimony. We'll be able to Men in Black their memory and get rid of the goddamn memory of the Woody's testimony and just restart. All right, I have to make a part 2 of this video because more stuff has happened. I was about to make the video you just watched public, and then I was like, shit, more just happened. The judge just responded to Yacht Gotti's motion for mistrial, and she denied it. So I'm pretty sure that means the judge has officially denied everything from the defense. Order denying defendant Kendrick motion for mistrial and supplement. The court has also considered the state's response, oral argument by the parties for the transcripts for the ex parte June 7th and June 10th meetings, blah, blah, blah. The motion for mistrial asserts 3 grounds for mistrial. Impossible to redo the proceedings that occurred on June 12th, 13th, 14th, and 17th before the jury, which, I mean, it kind of is. They're going to have to delete that from their brain. Defendant's constitutional right to be present at a critical stage of the proceedings was denied. Neither he nor his counsel were present for the June 10th in chambers on the record ex parte discussions. Defendant's due process rights were violated when the predecessor judge allegedly aligned himself with the prosecution team by his comments on the June 7th, the outside agitators. Kendrick also asserts the motion for mistrial was goaded by the state, where they basically did it all on purpose. I don't know if I believe that. I think they're just fucking stupid. Like the defense lawyers were saying the state intentionally did all this because they know they're losing the trial. I doubt that. Impossibility of addressing or redoing the proceedings. It's just about striking everything Woody did after the recusal motion, the 4 days, I think, or 3 days of testimony. The court has been working with the parties on which testimony and evidence should be resubmitted, represented for the jury, and whether any evidence at issue will be stipulated as to any needed rulings or instructions related to same. As such, the court does not find that there is an impossibility to addressing these issues, and therefore this is not a basis to grant defendant Kendrick's motion for mistrial. So once again, Judge Whitaker saying fuck you. A critical stage is one which defendant's rights may be lost, defenses waived, privileges claimed or waived, or one in which the outcome of the case is substantially affected in some other way. Brennan versus State, she cites. The judge is saying the same exact thing she put in the other motions. She's saying it all was about his immunity grant and other issues, and it was not a critical stage for the defendant to be present. I had a feeling she was going to rule that too. I've been saying this for like 2 weeks. Her attitude, she was going to act like this isn't a big deal, not a critical stage. So defense had no right to be present. She cites that shadow case again. No right to be present at a hearing to compel witness testimony pursuant to immunity grant. That's State versus Lowry. Chestnut versus New York. Ex parte meeting at the trial court's behest between court, prosecutor, and counsel for a witness. Initiated after defendant's attorney had left the courtroom during a recess at the close of the witness direct examination and held to ensure witness understood to deal with prosecution. So this has happened before in 2009. They found a case in 2009 where pretty much the same people were in an ex parte meeting. Interesting. Processor judge improperly coerced Copeland to testify. I think he did. She's going to say he didn't. I mean, telling him he's going to be in jail for years on end when you're wrong. They found cases where Woody would not be jailed for other trials. It would only be this trial, not the other defendants. Defendants searched that certain arguable inaccurate representations by the prosecutors and judge to Copeland about the law of derivative use immunity, statute of limitations. Under both the federal and state constitutions, a criminal defendant has a right to be present during critical stages of this trial. Defense counsel should have been afforded an opportunity to attend any hearing where a sworn witness in a critical stage of trial has been coerced to testify. She cites Webb versus Texas today like she did earlier, and Allen versus State, and Archer versus State, and all these witnesses were coerced to testify. Here, Copeland had the benefit of counsel. The processor judge did not, on the whole, use intimidating rhetoric, but rather sought to ensure Copeland understood the nuances of the decision he had to make. While it was likely that Copeland was not induced by any inadvertent or other inaccuracies to testify, so she's just pointing out she wants to re-instruct Woody of everything accurately, like she said earlier. So she's like repeating everything in other orders. This is about Glanville being biased right here, about counsel for defendants and witness Copeland, as well as about outside agitators. Defendant serves the processor judge during this conference revealed his partiality to state, pre-permitting the questionable accurateness of such characterizations or discussions. This issue has been mooted by the recusal of that judge. Okay. Once again, repeating what she said earlier. This is a lot of repeating. She just basically said, fuck you. Doug Weinstein tweeted this: I've requested a certificate of immediate review so an appellate court will have the opportunity to weigh in on the important issue of mistrial instead of wasting further time and taxpayer resources on this putrescent trial. I mean, they have wasted literally millions of dollars on this trial, so no remedies fashioned by this honorable court can cure the due process violations that have repeatedly occurred over the past 19 months. No instruction can cause the jury to unhear Mr. Copeland's testimony. A fair judge going forward can't cure a biased judge presiding over this case in the past. She pretty much is. Whitaker is hiding the bullshit under the rug that Glanville did. She's saying he's off the case, so y'all got what you wanted. Defense had no right to be present at a critical stage. There was no Brady, apparently. I think the most embarrassing part about all this is making the prosecutors have to go through that class on Brady. If that's not an indication that this trial should be over, I don't know what is. You have to punish the prosecutors? Has that ever happened before? In a trial this serious with so many people's lives on the line, it's fucking embarrassing. This whole thing is embarrassing. You know what's funny about all this? Even if we continue with the trial and waste another 6 months, and somehow the jury says they're guilty, it's gonna get reversed in appellate courts because of all the bullshit. I love you guys. Hit subscribe. 10 cents per day for the channel membership. Merch coming very soon. Peace out.